Okay, let's talk about the different means of dispute resolution, the different types of dispute resolution systems. Now, there are advantages and disadvantages to each type of dispute resolution mechanism, starting with negotiation. Now, negotiation allows the parties to resolve a dispute without the use of any third party, meaning just the parties are involved. And there are certainly a number of advantages to negotiation. Number one, very inexpensive. Could be as little as writing out an email or picking up a phone, maybe writing an actual letter. In any event, not a lot of cost involved with negotiation. It is also possible to have the negotiation be completely confidential. Because there's no third party involved, that means that everything having to do with that dispute, all of the issues arising out of that dispute will be kept confidential between the parties. Another advantage of negotiation is time saving. It's a huge time saver to simply pick up a phone and call the other party, or arrange a face-to-face meeting with the other party, sending a letter to the other party. That can be done quite quickly, and time can often literally mean money in the business world. Another advantage of negotiation is that the parties are familiar with the facts. There's no need to educate a third party, whether that's a judge or a jury or an arbitrator or a mediator. The parties already know the issues, they already know the facts, and again, this can help to push the resolution along. Now, having said there are advantages, there are certainly disadvantages as well. And disadvantages come in terms of negotiation from the fact that without a third party to push the parties in one direction, what often happens is the parties become locked into their pre-existing position. The parties become fixed on their position. And many times parties are unwilling to compromise or to attempt to compromise for the fear that the attempt to compromise is going to look like a sign of weakness. And so in a negotiation, it requires the parties to give and take. And if you are concerned that that give and take is going to be considered to be a sign of weakness, parties won't engage in the type of resolution that they need to. Another problem with negotiation, again, without a third party, sometimes it's hard to understand the viewpoint of the other party. It's difficult to comprehend other people's problems or other people's view of the situation. We have in our head one idea, and that becomes fixed as the truth. And so it can be very difficult to hear someone look at the same, or to see someone look at the same set of facts and arrive at a different truth. So advantages and disadvantages of negotiation, make sure you know those for your exam, for your writing assignment. Now, litigation has advantages and disadvantages as well. Litigation is the primary means of resolving disputes. So that's pretty good. It's the way that we're very familiar with resolving disputes. Litigation also allows us to get a final judgment. And the final judgment is an order to the state to enforce the judgment. So if I get a judgment against another party, I can take that judgment to the local sheriff or constable and have that sheriff or constable go out and take the property of the party that lost the lawsuit and sell it and pay me off. So the ability to get an enforceable judgment is huge that's a huge advantage for litigation. Litigation also can be an advantage if you are in your home country. If the dispute is between you and a business in China, and the matter is being held or is being considered in district court here in Oklahoma, well, that's a huge advantage for you as well. So depending on that, if you can get the other side to agree to choice of forum being in your home area or your home country, well, that can be a huge advantage for you. Now, there are, of course, many disadvantages to litigation. The first, and of course, maybe the most important for you as future business people, is that it's very expensive. It's hugely expensive. You got to hire lawyers. You got to go through this long, involved process. There's going to be a lot of legal fees on the way to trial. And then if you wind up going to trial, well, you're looking at even greater legal fees. It's very time consuming. People don't realize how long it takes to have a lawsuit work its way through the courts. You could have a claim against a party for breach of contract, and if it takes you 2 or 3 years to have a court finally decide on your claim, maybe you've gone out of business in the intervening 2 years. So it's very time consuming. There's a lot of formalities involved with litigation as well. There's a lot of extensive rules, and these rules tend to be inflexible, meaning you have to have certain documents in on a certain date at a certain time, and those aren't subject to change. So very inflexible rules with litigation. And finally, mediation. Now, mediation, we're going to talk about arbitration in a second. Mediation has a lot of advantages and disadvantages as well. When we're talking about mediation, what we are talking about is using a neutral third party to assist in resolving the dispute. Mediation, you can think of it as sort of an assisted negotiation because it's non-binding. Nothing that occurs in mediation is going to bind either party. Instead, it's about getting the parties together on the same page, trying to create a win-win situation where the parties can be assured that the other party is not taking advantage of them. It might not be such a win or lose situation, but you may not get as much money as you want, but you're going to get something. Or you may not want to pay zero, but you may have to pay a little bit more. So mediation uses a neutral third party to assist in the resolution of disputes. Now, there are a lot of advantages to mediation, and mediation has taken a huge role in the law, meaning that nowadays, most every dispute, every lawsuit, before it actually goes to trial, must go through a mediation. So a mediation, the advantages are inexpensive. Now, it's not as cheap as negotiation because you're going to have to pay the mediator, and you're going to have to take time away from your work to attend the mediation. So there's a cost involved there. But overall, it's very inexpensive. Most mediations, regardless of the size of the dispute, can be resolved in 1 or maybe 2 days. So mediations are meant to be a relatively inexpensive form of dispute resolution. Mediation can also be very quick. If you, in your contract, you call for a mediation before filing a lawsuit, well, we can have a mediation very quickly. We can just find a mediator and have a mediation in very little time. Mediation is confidential. And again, it's not as confidential as negotiation because the mediator is going to be made aware of the facts of the case, but it's still confidential. And nothing that is said in a mediation can be admissible in court. Mediation, often one of the advantages is that people can apologize without fear of that apology being introduced as evidence in court sometimes later. Sometimes plaintiffs just want to hear, I'm sorry. And so we can do that in the context of a mediation. The non-binding nature of mediation is also an advantage, or can be considered an advantage, meaning even if the parties don't get to a resolution, Nothing says that they have to take whatever the final offer was, or they have to give up whatever the final demand was. It's non-binding, so parties can enter into a mediation without fear that if it goes badly, they're going to be hurt by it. There are disadvantages to mediation as well, and I'll start with its non-binding nature. In a mediation, what this means is that it requires a good faith effort to settle the case, because it's non-binding, meaning all the negotiations that we go through in a mediation may not have any effect, and it may turn out to be a wasted trip. Mediation is also problematic in that if there hasn't been no lawsuit filed, there's no means of discovering evidence from the other party. There's no way of getting evidence from the other party. And if evidence is what you need to establish your case, then you're going to have to file a lawsuit anyway. And so the mediation may not save you any time or money. If you do reach a settlement at mediation, but the other party fails to pay the settlement, what that means is then you have to file a lawsuit to enforce the mediation settlement. And so therefore, even in the event of what you would term a successful mediation, you still had to wind up filing a lawsuit. Now, filing a lawsuit becomes much easier because now it's just a breach of contract claim having to do with the payment of the mediation settlement amount.